Okay, I'm going to call the meeting to order. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can I get a moment of silence, please? Okay, thank you. I want to thank you everybody that's here and everybody watching or will be watching. I'll start now with roll call. I'll start with Commissioner Doug Smith.
Here.
Commissioner Mike Stephen.
Here.
Mr. Jeff Culberson.
Here.
Mr. Vic Cause.
Here.
And Mike Smith is here. Very good. Public comment. I think we have one. Joe? Come on up, sir. Good morning.
You're the first contestant.
Joe Herring Surveying, 315 North 5th Street. Appreciate you letting me take some time to talk about the comp plan meeting that's going to happen today. I send emails, and I've sent emails all along before every work session, before every planning commission meeting concerning the statements in this comp plan. The map is probably the biggest of the concerns. Through the work sessions, which I attended up here, I thought the board was very direct, very specific on that's not going to get adjusted. I thought staff also commented on that was not the desire of the board, yet it's in front of you with an old layout that wasn't approved by this board. It's only been in effect for just over a little over a year. It's just taken its hold. So I really don't want to see that adjusted, but if it does happen to get adjusted, if that's the wish of this board, would like to see this board pursue hard zoning the county to that map so the people that own the property within that area have some sort of confidence that they can plat their property when it meets the county regulations. I mean, there's already talk of rezoning issues that may not happen, but when it meets all the regulations, the people should have assurance that this board will support it and staff will support it. The discussion about rezoning a platted subdivision, I do understand that concept that people that buy within a developed a subdivision, they have some inherent idea that this isn't going to get rezoned and built out to a higher density. But we need to get some definitions with that. What defines that? We have some 2-lot subdivisions, 3-lot subdivisions. They're only called subdivisions because that's our regulations. They're really not platted, developed areas with an interior road. And we've had some others that we were forced to plat because of the current planner that is no longer with us and take a 40-acre, even I have a 90-acre lot out there that we had to plat in the subdivision. Doesn't make sense to me, but that's what was required, so we did it to get the plat through. Those should be given different considerations, and I would like those, talked about instead of just blanket description on those. Established neighborhoods has come up. There's no definition to established neighborhood. That concerns me because it allows just for anybody to, not anybody, but it's just too vague. It needs to be defined what is an established neighborhood. I put in an idea that an established neighborhood is any property that was, established or a neighborhood that was established with an interior road. We've had interior roads built where property was not platted, 5-acre subdivisions. That's been brought up by a commissioner up here, as an example. Okay, I understand that. That is a developed, established neighborhood. But we need that defined. They're vague, and that discussion just hasn't been allowed and hasn't happened because we're only given 3 minutes at the Planning Commission meeting one time. We're given 3 minutes here. We're allowed to send in emails. I think in the packet, my email was in there. There might have been 4 or 5 others. There was more to it, but you've seen my email. Thank you.
I did, Joe. Thank you. Thanks for your comments. Okay, I don't think there's anyone else, so administrative business. Mark?
One, I'd just like to remind everybody that there is a special work session next week on the 5th at 6 p.m. for Front Community Center, a joint work session with the City of Leavenworth
Anything else, Mark? One thing I'd just like to bring up, one of the planning commissioners in my district is moving away at the end of May, so if we can start the process, I've talked to Crystal, we can start the process, Mark, to advertise for that planning commissioner. We okay, Mark?
Yep.
Okay.
I will have that advertised.
Okay, thank you. Anybody else have anything on this part?
Yes, sir. Chairman, I'd like to recognize the passing of Anna Mary Landauer, probably our oldest registered voter in the county. She was 103. I believe her birthday would have been May 5th, Cinco de Mayo Day. So, visitation and wake tonight at Holy Angels Church, funeral tomorrow.
I'm glad y'all
She's
could
been
call her.
103. 103, and last time I spoke with her, she had some concerns on the money we had pledged to the 155th Street project in Baser. I had to explain that to her. So she's very active, very sharp, and she will be missed.
Yes, that's true.
First woman mayor of Baser back in the 80s. I believe. Nope, she's been very active all these years.
Good person. Any other commissioner have anything on this portion of it?
Well, just as I'm sure all the commissioners have been getting some calls and emails and drop-ins on property taxes and valuations and all that. So everybody should take that opportunity to explain the state statute that how appraisals are done, and use that opportunity to talk about the local ad valorem tax and demand transfers that the county has not been receiving from the state. And I don't know if anybody watched the other night, Channel 5 had a deal about out-of-state buyers are buying up homes in Johnson County as soon as they come on the market, and some of them are paying over $100,000 above asking price just to get it. So it's kind of hard to get a fair comparable when it's like that.
Things going on like that.
Yeah.
And
Go ahead, Mike.
Oh, well, I was going to bring up it's sort of along those lines, but I wanted to address with the county counselor. Can you address the relationship between the county commissioners and the appraiser's office? We appoint the appraiser, but our authority over the office, can you address that?
If we could, addressing your first point, yes, the Board of County Commissioners does formally appoint the county appraiser. However, you appoint that county appraiser from a list provided to you by the Department of Revenue of persons who are qualified for you to consider to be appointed as county appraiser. And in fact, were you to not appoint somebody that met with the approval of the state of Kansas, they would basically override your decision and appoint somebody else. You do fund the office of the county appraiser. The office of the county appraiser occupies space in this courthouse. Its employees are county employees. However, you provide no direction, no control, and have, quite frankly, other than county personnel policies, no authority over the office of the county appraiser. County appraiser uses guidelines and formulas provided to him or them by the state of Kansas. You play no role in that calculation.
And commissioners do not go into the office and have anything to do with setting or helping to set the valuations of people's personal property.
Commissioner, I think if you were to visit the office of the county appraiser and attempt to do that, you would be invited to leave, or he would disregard your comments.
I think there's some confusion on social media about this issue, and I think that needs to be clarified. And second issue I was going to bring up this morning is when we meet with the city of Leavenworth, I think we should suggest, and I want to see what the rest of the commissioners thought, but if we could set a summit up with all, and possibly meet at the Riverfront Community Center. It's a nice meeting space and big room, but invite all of the taxing subdivision and entities, at least to have a representative there, and hopefully get Leavenworth on board next week to assist with doing this. But if we get everybody on board to talk about property taxes in the county and how all the subdivisions of the county can work together in tandem, and then we can lower some of the property taxes. But the real problem is on the state level, and also if our legislators would attend to get that feedback. I think people need to know that we understand this is a problem, but it's a problem that's multifaceted. It's not something the county commissioners can solve, but this is an idea I wanted to throw out and see what other commissioners.
Or we could get all of our money back that's due to us from the state.
And that would be something to discuss.
Oh, okay. All right. And then would this include school boards?
Yes, we'd invite
All
them.
right. Because that's a big one.
And that's what I was just going to add to what Doug said is I don't know where the idea started. If these little groups that are concerned about taxation and raising values and raising taxes understood exactly how it works, I think they could actually get something done. But I don't know how the idea started that the county commission controls how much you pay in taxes. We control about 25% of what you pay. So we're going to do our part when we get to the budget cycle. We've lowered the mill levy every year that we've been up here, and we're going to do as best as we can. But even if we do as much as we can, it's only 25% of what you're paying. 75% of what you're paying, we don't have any control over. So I don't know how this idea started that the county commission controls how much you pay in taxes. So I hope these groups, I'm speaking at one next month.
You mean the county commissioners don't go over to meet with the appraiser and say, we need this amount of dollars, you raise everybody's appraisals till we can get to that mark?
Exactly what I've heard.
I have too. I have too.
Yeah, nothing to do with that.
You know,
so.
Jeff, I think the whole thing that confuses some people is the title, county appraiser, when it really, that's misleading.
Yeah.
It's state,
Yeah.
basically, because that's the formula that's being used, that we have to abide by law.
Yep, exactly. And
But there's such a difference when you're talking a 15% average. I mean, somebody's went up 25%, and somebody's got lowered. And so for us to be able to lower the mill levy enough to offset somebody's that went up 20%, it's just no way.
I think the whole thing needs to be redone. I mean, as far as I'm concerned,
we've got to fix the
we
system.
got to fix it. I think we got people moving out. I think the elderly, or when you get a certain age, I think maybe there should be a special rate for property tax on that. We've got people leaving the state because they can't afford to stay in this area.
And
Something has to be done to fix this.
And that's, Commissioner Stevens and I heard someone speak a couple weeks ago that Kansas lost 1,300 people. Is that what he said? Every state around us gained population.
Oh, yeah. That's what he said, yeah.
Every state around us
that,
is
Doug.
gaining in population, and
we
the
lost.
state of Kansas lost 1,300 people. 1,300 people may not be a big deal, but it's going the wrong way.
It shows a trend, and
It
that's
shows a trend, and they're being taxed out of here.
That's exactly right.
So
But if we have this conversation with the other entities, and maybe they won't be able, some of them, to make a full mill reduction in theirs, but if everybody's talking and communicating and the legislators are invited and involved, and like you said, the LAVTR needs to be funded. That hasn't been funded for years, and maybe I don't think some of our legislators have that on their agenda or on their radar. And
we've brought it to their attention
Several times.
It's more like a subliminal message, but
But if we invite them and they don't come, that'll speak volumes too. I think maybe we'd talk to the Leavenworth commissioners if they're willing to help us co-sponsor this.
all the states around us are increasing in population, and we're losing. So,
Well, I guess with Mike saying, I guess if the commission's okay with it, we could chat with Leavenworth next week and see what their thoughts are on it. Jeff? Vicki? All right. That'll be one thing we'll add, Mark.
Commissioners, just kind of want to clarify a couple of things on the discussion that was just held. One, the county appraiser's office does fall under the state and the county, but the calculation that he's provided is state only. The county has no impact on that.
Right.
We've tried to impact it, tried to get that changed, and we haven't had it. And the county appraiser performs very well.
Yeah, for
I
what he's
don't want there to
given.
be any, like, we're trying to isolate ourselves from him. The
Yeah.
county appraiser's office in Leavenworth County specifically does an excellent job. They follow the state statutes, and they're required to be within 10% plus or minus of the market value of your home. And we're actually on the low side of that to the point this year that this is the first time where we're actually a little too low, and that's why some of the adjustments that you're seeing. So you're handed a playbook. You have to play by that playbook. And that's the hand that the county appraiser's dealt. I don't want people to think that this is somehow on their shoulders. They're doing what they are instructed to do by the state, and they do a very good job of it.
I think it's very true, and that was implied. It sure wasn't meant to be, because you got great staff over there. The catch is this is direction and this is law, the way they have to do it. And like you're saying, Mark, and so they end up being the fall guy or gal for this.
Mm-hmm.
David?
Yeah, Commissioners, if my comments were taken to in any way impugn the integrity of the Office of the County Appraiser, it was quite the opposite. The Office of the County Appraiser, as Mark referenced, does an excellent job. They're recognized as one of the higher performing appraisers' office in the state of Kansas as far as the integrity of their work. However, I think people need to realize they essentially gather data.
Mm-hmm.
Put that data into the state's black
That's right.
box that is given to them, and that black box produces a number, your appraisal.
Yep.
They have little to no, in fact, virtually no discretion in how your appraisal comes out.
So if a person, and this is a social media issue as well, if you have accusations or you have complaints and you don't believe things are being handled correctly, we have a process for dealing with that. You can bring it to the commissioners. We can present it to Mark. He can present it to the appraiser for an explanation. And beyond that, it could be referred to the Attorney General or to the county attorney. But just putting out accusations on social media that are not correct or don't have evidence is irresponsible.
It's
and
extremely irresponsible.
What's that?
It's extremely irresponsible.
It is. If you have a problem or accusation that is a direct accusation against the appraiser's office, you should bring it to us, and we can bring it to we'll go through the process. And because we follow the rule of law, and that's what our responsibility is. But putting it out on social media that Leavenworth County is doing things any different than any of the other counties, because every county is having these, especially in northeast Kansas, large increases in valuations. So it's not just a Leavenworth County issue.
And I think that, unfortunately, we're doing a very poor job of several things in our, probably in our system of education as well, is in educating our youth and even our adults in the processes of how things are done in government, how people are taxed, what the process is, how do we come up with appraisals, who is responsible for what, as in many people don't realize who is responsible for setting the valuations, who is responsible for making different laws, and then who are our elected officials. And then I think that Commissioner Smith and I found yesterday that we had an individual who was not aware of who his state representative was and who his state senator was. And so when you don't have that awareness, and then you're not aware of the fact that the county is not responsible for making those decisions, that the county cannot adjust your property taxes because there is state law that comes into play, and that we cannot do that we have no control whatsoever of what happens once your property taxes are established. And I think that people think we can do that we can just say, okay, well, then we're going to adjust your property tax. We cannot do that. Legally, we can't. We wish we could. It would be really nice if we could say, well, you're over 65, therefore, and your income is this. We would love to be able to say, then we're going to give you a tax break. We can't. The state of Kansas can.
And they should.
And they should.
And the bigger problem here is until the state of Kansas finds another source
Right.
to pay our bills with, it's going to be a problem. You know, Colorado and Missouri have cheap taxes, real estate taxes, because they have another source. They have tourism. Colorado has the mountains, Missouri has the lakes, and they both have medical marijuana now. Oklahoma and Texas have cheap taxes because they've got oil to pay their bills with. So they take the burden off of real estate. Until Kansas finds another source of income, this is going to be a problem.
And that's directly true in Leavenworth County, where we have 74% of our, comes from residential, as opposed to like Janet brought up in her presentation was Pottawatomie County. They have a coal-fired power plant. They're getting taxes from it, so residential is only 56%. So the more Hill's Pet Nutritions and industry and commercial that we get in, that reduces your taxes. And the more large, expensive homes that come in, that helps to spread the tax burden.
But I think a lot of times people don't understand that we as elected officials cannot force a business to come and locate here. We can't tell someone that they have to bring a business to our community. You know, we can't make a Hill's Pet Nutrition come to Leavenworth County. They have to want to come here. We can't force a grocery store to locate in a specific area of our community. They have to decide based on all different types of factors.
And population is
And population is one of those things. But we can't, as governing bodies, tell a business, a private business, that they have to come here. As a state, we can't tell a business that they have to come to our state. They have to make that decision privately on their own. And I think a lot of times people don't understand, well, you know, I elected this governing body. They need to make this business come here. Well, we can't make them. We can ask, we can encourage, but we can't make them.
I think one thing, being on the other side of that and having to bring, or was fortunate enough to be working with people that brought businesses in the city of Lansing, Quick Trip, Harbor Freight, something like that, I think the county took a big step by hiring a person to oversee and look at that. And Vicki, you're absolutely right. But if we can court somebody, and what we've got Tom doing, to look at this, at Lansing, at the county, Lansing, Leavenworth, Basehor, County, Linwood, Easton, everybody, then I think that will help tremendously. One of the things I've looked at before on this property taxes, you know, I think people understand that everything costs more every day. But there's no smooth way to get there right now. It's, okay, we're going to go a little bit, then we're going to jump 20% or 19%, then we're going to come back down to 8%. It was a gradual pace to get there. But I think one of the things Doug is saying is absolutely correct. With the housing market, when you've got these comparisons right now, being around the person that just paid $500,000 for a $300,000 home, it catches up with you.
And the average price of a new home in Leavenworth County, $374,000. I mean, things, you know, it's the direction things are going, and the legislators need to change the fact that valuations drive the tax issue.
Right, and then we're pricing out young home buyers, and then there's lack of affordable housing. And we're not having enough even rental properties for people to come in, so we're impacting employment opportunities because.
They can't hurt anyone. Yeah, I agree.
So we really need to work at and find answers to some of those things. It's a complicated situation that we're finding ourselves in right now.
But we've been dealing with it now for. I know it's gone on for many, many, many years, but since I've been on the commission, all 3 years, it's been. This is not changing. This is getting worse.
It's getting worse, yeah. There is a shortage of housing.
Yes, there is. Mark, did you have anything else? Okay, and we're going to see what the city of Leavenworth thinks about that at their next meeting. Was there anybody else on the administrative business we need to speak of before I move on? Okay, if not, is there anything, I'll move on to the consent agenda. Is there anything on the consent agenda that needs to be pulled? If not, I'll take a motion.
Mr. Chairman, I move that we accept the consent agenda as presented.
Second. Motion is second. Any discussion? Okay. Roll call. Commissioner Smith?
Aye.
Commissioner Stevens?
Aye.
Mr. Coverson?
Aye.
Dawes?
Aye.
And I'm voting aye. Very good. Okay, formal board action. Consider a motion to approve Resolution 2022-8, amendments to Article 22, special use permits and temporary special use permits. Good morning, Crystal.
Good morning, Mr. Chairman and Commissioners. How are you? Okay. First item we have before you is Resolution 2022-08, This is the special use permit language that you all have been talking about for the last several months and have directed staff to take a look at. The largest change here is that we are proposing an amendment that would allow special use permits to operate without expiration. In the event that they are operating within the confines of their special use permit, they are not expanding or anything like that. As long as they are doing what was approved, they will not need to come back every 5 or 10 or 15 years. They will just be without end. It will be very clearly stated that if they are going to expand, that they need to either build that in up front, or they need to come to us after their special use permit has been granted to speak with staff to determine whether or not they need to come back before the board. So while it is without expiration, again, that's only under the terms that it was approved.
Existing terms.
Yes. So I just want that to be clear for anyone who may be listening. It doesn't mean that a special use permit would never be reevaluated. We would keep an eye on them. Primarily, that is through code enforcement. And as you well know, the majority of the way that we find out that businesses are either operating outside of the parameters of their special use permit or without a special use permit is when a neighbor calls and lets us know that something is going on. So, and we will also make it a habit to, we have a list of all the special use permits. We'll, drive by periodically, make sure things are as they should be. We're not going to over-enforce or anything, but we're also going to keep an eye on things. Within that, one of the things that the board has asked is that there would be a bit of a grace period on special use permits for, I believe, 6 months is what we have talked about. And essentially what we're going to do is we're going to put out a social media campaign that says, hey, if you're operating a business out in the county, you need to come in, you need to get your special use permit, and let's get you legal. After that 6 months, if that has not occurred and we determine that someone has been operating a business, then they will have to pay a double permit fee, which is the same as what we do with construction out in the county. So that will take place going from this point forward, assuming this is approved. Additionally, staff did recommend adding a Type 6 under the temporary special use permit regulations, and what that will allow for is a special use permit that would normally be considered as just a regular special use permit, but if for some reason the Board of County Commissioners did want to put a period of time on it, we've got a couple of them out in the county currently. As you know, the Board of County Commissioners has said 3 years and that's it, then you need to move. So that Type 6 under temporary special use permit would allow the board, in instances where the board felt it was necessary, to go ahead and add that condition that there is a time frame. And then also we cleaned up some language. There were things in there like we requested 20 site plans. We don't need 20 site plans. It's 2022. We do things digitally. Also items where it said that staff reviewed every special use permit on a yearly basis. That has been removed and cleared up to really reflect more what staff is capable of doing with current staffing. The Planning Commission recommended to approve this. Obviously, staff also recommends approval, and I'll answer any questions that you may have.
Commissioners?
Yeah, I'll start. And what would the fine be? What's the dollar amount?
So currently, a special use permit is $400, so it would be an $800.
Okay. That's not a very stiff fine, but that's all right. I do have some concerns. Did we ever establish what ag tourism or ag that they don't need? Have we got a good, solid answer on that? Because it seems like we've got some that have to have a special use permit, some that don't. So I'm just got a concern on that.
The answer is no. There's a state statute that creates agritourism as a recognized business in the state of Kansas and grants to it the exemptions that are offered to other agricultural uses. As far as any firm determination or criteria as to what comprises or meets the criteria for agritourism, there are no Attorney General's opinions of any substance. There is one codes court ruling out of Johnson County that I'm aware of that I think it should be given the weight that it's out of a codes court case that was not appealed to district court. it is a fluid situation with respect to the definition of what meets agritourism. I anticipate that there will be some legal definition given either through court action or possible modification of state statutes.
Well, I think we have a few of them out there that fall under ag tourism that we have granted special use permits for. And I don't know, are we going to deal with them when they come up for renewal, or how are we going to handle this?
But they won't come up for
Under
renewal.
under this policy, existing special use permits will not come back.
Okay. So this will take care of itself then? Or, well, I guess we got to establish who has to apply for one in the future.
Are you
On
talking about
agritourism? Yeah, I'm talking about agritourism here, because that's a big thing in the state of Kansas right now.
So the way that staff has handled these cases in the past is if you grow a product on your property, let's use wine as an example. Okay, so you grow grapes and then you ferment the grapes and you turn it into wine. That does not need a special use permit. That is protected under agriculture. What happens, we have one out in the county in particular, they do that, but then they also have a retail market on their property where they sell their wine. However, they also import goods from other places that they sell. They sell wine glasses, they sell T-shirts, they sell food, they sell a number of things that are not actually grown on the property. And so their winery does not require a special use permit. Their business that is retail sales did require a special use permit. And then we have others where they have an event center on their property. And granted, their event center is located in a barn or a structure that was built to appear to be a barn. It generates significant traffic. We have one out in the county where they hold events of up to 500 people. And originally that was on a gravel road. They have worked with us extensively on taking care of some of those issues. From staff's perspective, while that may be agritourism, it is also something that is causing a pretty significant impact on your neighbors. And so that is the job of our department and the board, is trying to ensure that someone can use their property to the fullest extent while not negatively impacting their neighbor.
And I believe that's what the lawsuit in Johnson County was on, was an event barn that grew their own products and had them there at that event center.
So we have some event centers that do not grow. Right. They don't. So that's what I'm talking about.
Well, that's a different deal. I just want to focus on the agritourism thing. We've gotten several out there, and I know since I've been here, we've granted some special use permits. I just don't think they really needed a special use permit for what they do. But I guess when we got to deal with it in the future, I guess we can deal with it. But speaking of dealing in the future, on any new special use permits, I'd almost like to put a moratorium on them right now until we get through we have, 3 in court right now on special use permits?
Commissioners, we have 3 active court challenges regarding special use permits and have 1 notice of claim pending regarding agritourism issues.
Okay. Well, I would like to wait to see what the judge decides. Do we have jurisdiction? Do we have authority over these? If not, then why are we wasting our time?
And this moratorium would be just related
special
to
use permits.
Special use permits for
anything.
For anything?
Yeah.
I mean, because special use permits, like you have a cabinet act. I mean, it could be beyond this ag tourism issue.
No, I'm not. We're shifting gears here. We're out of ag tourism. We're just talking about special use permits. If we don't have the authority to set forth or enforce any of the conditions that we put out for a special use permit, it's being challenged in court right now. Or do we have the authority to deny a business going into a residential area? If we don't have that authority, why are we wasting our time? Let's let the judge decide. Before we keep digging the hole any deeper, let's let the judge decide, and that'll give us direction on what authority we have.
maybe we need to get a legal, maybe we need to.
I would really, if that would go that direction, that would really change the game. That the county commissioners cannot oversee something like that. David, what's your thoughts on that?
Commissioners, if I may just
Mark,
real quickly, I think we've talked about in the past on this, and it was probably in the last year I maybe brought up even that's the danger of these special use permits, or the challenge, I guess, with the special use permits is that you're not doing a permanent rezoning, you're doing kind of a conditional rezoning. And that we assume as a Board of County Commissioners that you have the right to revoke a special use permit when somebody fails to comply with the conditions that are set forward. But what we see now is that when we try to exercise that right, it gets challenged in court and can cost the county a lot of money to defend that position, which is why, as staff, we've cautioned for a while about issuing these special use permits. I know we want to be friendly to business in the county, and we want to allow people to utilize their property for usages that maybe it's not zoned for, but that we want to see them be successful in their private businesses. But it creates challenges like this that then end up, it's not us that ends up making decisions, it's court. And I think that's what Commissioner Smith is saying, is that until we find out how the court's going to rule, whether or not we have the ability to enforce these conditions and revoke a special use permit when somebody doesn't comply, it maybe puts us at risk if we continue to issue special use permits that you think you have the assumption that you can revoke when you actually can't.
Then you'd be talking more about rezones.
They'd all have to be rezoned.
And that was the conversation that we had earlier, probably in the last year, was that versus SUPs, maybe these businesses should be looking at rezoning so that they have the full protest period and all that. And I know we didn't want to do that. So
At the time, yeah.
But I don't want
I understand that.
we want to stop the lawsuits, Commissioner, don't we?
Yep.
So
Absolutely.
I'm just trying to protect the county here.
I would support that. Maybe we can.
I mean, I can't really
not on our
table this
agenda
to a
today,
certain
but-
date because I don't know when the certain date's going to be.
But I would support that, considering a moratorium until we can get some, look at some of the outcomes. Because, the thing is that people seeking places to do businesses, there are within, and we're investing as a county in several different business parks and places for people to put businesses. We have set aside properties as we have begun to designate use maps on places, where there are zoned specifically for different businesses and mixed uses and uses. So, either we are going to have a county that has zoning or we're not. And then if we're going to have a county that allows for special use permits, we need to find out if we're actually have the authority to enforce the conditions of those permits or we don't. And then we can at least be thoughtful in how we go about that, or do we just go with rezoning and we don't do special use permits? Because if we...
That's a possibility.
Well, why don't we have a work session on this and get all of the legal opinions that are possible on this before we make a blanket decision, so we have all the facts. I just think...
But isn't that kind of a moratorium? Basically, isn't that what,
well,
what we're saying?
I guess what I'm having an issue with the moratorium is we're going to give people 6 months. We're going to do a social media campaign and tell them, if you're running a business out in the county, you need to get in compliance, and then we're going to turn around and say that, we might not issue that anyway, so we need to kind of figure out what the policy is going to be, and maybe we should even hold off on this adoption of this SUP policy.
I think we should, but you can get all the legal opinions you want, but at the end of the day, it's whatever the judge decides. That's going to be the ruling we have to live with.
And sometimes, Dave, correct me if I'm wrong, sometimes these things will go on for a few years. Do you think these would?
Commissioner, if I could, and this is partially speculative, but the time period between the day that an action is filed in Leavenworth County District Court and a final ruling is provided by the Kansas Supreme Court could be anywhere from 24 to 48 months, and probably closer to the 48.
That's what I've noticed in the past.
Mr. Chair, but we can
Yes,
at least
yes, go ahead.
get an initial ruling that would come from the district court that would give us an idea of where we
And then
stand.
if it appeals, that's.
I mean, it can at least give us an idea of
So are you saying we should table this for now?
If we don't have a definite date to table it to, we'd have to.
Or we can
We could do it
revisit
and then revisit it again at a certain date.
So just to make sure you all understand.
We'd
that
have to
if
send
you
this
table
back to
this- If you table this topic, this SUP topic, SUPs still exist, they just exist under the current policy.
Right.
You haven't
I'm not talking
stopped
about
that
just
part.
new ones.
Well, new ones are still going to exist because our policy still allows, this is
No,
just,
anybody
what you're
coming in
tabling
might be
here.
approved.
Yeah, what you're tabling here would be the change to the SUP policy,
until we know if we
Which-
can even.
still leaves the current SUP policy in place.
right.
So if you want to
We'd have to put it on
forbear
the
issuing any
agenda.
new SUPs, that takes a separate action.
That'd have to go on the agenda.
Right.
Be voted on next week
Right.
or sometime after. But I'm just saying, I just don't want to keep digging the hole here. If we don't have authority over this or any jurisdiction.
So I guess to start the process, well, I move that we table this for what type of time frame? What do you think?
I don't. When do you think at least one of ours will be heard? That the actions against us.
It could be a couple
Heard and
years.
decided are two different things. The commissioners, I think you'd be looking at sometime next year.
Okay.
So I guess we'll table this for.
And then, again, before you take that action, what that does then is it means that any of the current SUPs that are coming up will have to come in and make application to renew. This change here only removes the renewal process. It doesn't.
And that's what I liked about it, because that's the only thing that it affects.
So
Go ahead,
if
David.
you table this, then anybody who in this year has an SUP that's expiring will have to come before the board to get it renewed. That's all we're changing by tabling this.
Commissioners, the decision as to whether to table this matter, adopt it or not adopt it, is a policy matter solely within your purview. However, if I could speak to one issue, and that is, as Mark pointed out, the real change, the substantive change that's contained in this proposed amendment is that the renewal process would be more or less made, I'll call it automatic, unless problems were encountered, in which case provisions are made for appropriate review. It was determined in examining this issue that roughly 90% of the special use permit actions that you hear are renewals, and 90% of that 90% go through with no opposition, with no complaints from the neighbors, but still require that the applicant pay a fee, go through staff review, go through the planning commission, and finally appear before you. That's a great deal amount of staff time, planning commission time, and your time. So I think the issue of economy of time and economy of use of county resources still exists, and I would suggest to you that by adopting this, it would not prevent you from looking at, I'll call it the bigger picture, as to what is the role of special use permitting at all in the county zoning process.
Except for the fact that we're going to go out on social media and ask businesses that are currently operating to try to come and get in compliance, and we're not even sure if we have a legal standing.
Mm-hmm.
So do we really want to go through with that process of the social media and all that?
Commissioners, without going into a rather belabored review of Kansas planning and zoning law, which is rather voluminous, you do have the authority under statute to consider and issue special use permits. I think Commissioner Smith certainly correctly, Commissioner Smith's concern is to how broad are your review powers with respect to enforcing those conditions. You do have certain instances where those conditional requirements are challenged, but the overwhelming majority of your special use permits do not fall in that category. And I think the benefit that is offered by the amendment that deals with the renewal process is significant and could be gained without circumventing a review of the, I'll call them the problem SUPs.
Well, I walked in the door thinking I was going to vote for this, but then Commissioner Smith raised these issues, and I do think they are significant issues. And I just don't know if we certainly want to go out on social media and tell people, get your businesses in compliance and bring your applications for special use permits if that's premature.
Well, you know, Mike, it's just going day to day. I think this is just more of an operational procedure than it is anything else. It gives the opportunity for to make it easier for some of the people that do have the ones. I totally agree with you and Commissioner Smith are saying court's going to decide for us, but I don't think we can stop now until wait a year or two, and most likely be 2 years to keep putting these things off. We're doing what we think's best and what we believe is allowed to go forward with this to make their job and the people getting the SUP easier. So while I have the concerns about, they may come in and say, hey, you're not going to do it, then everybody have to start doing a rezone. I sure was like, unless there's something else, and I understand about the social media thing, I still think that this is the right way to go for now.
So
just my 2 cents. Go ahead, Biggie.
what we're saying, or I'm trying to get a little bit of clarity here. What would happen is moving forward wouldn't be asking people to do a special use permit, is if we're identifying people who are non-compliant because they're operating a business, rather than coming in and asking for a special use permit, they would be coming in and asking for a rezone?
I don't believe
That would be
No?
if there was a policy
That's one
change.
option.
I mean, or would that be?
Or if the court changed, said we couldn't.
We'd have to change this.
The agenda item today is
No, I'm just
changing
saying
the
if.
current SUPs.
Just hypothetically
Current
speaking.
SUPs, not new SUPs, only
Right.
current SUPs.
No, I meant hypothetically speaking, that could be an option as opposed to a special use permit.
Well, I don't think we're counseling the procedure
No,
right now.
I'm just-
That should be,
No.
but I think the rezoning is the next step. If
Right.
that's the way we
Right.
go.
I agree with Commissioner Stevens is that we're going to be offering amnesty for these folks to come in here, and then they may not get approved.
In the long run.
You never know.
Well, either way, they would continue to operate illegally, I guess.
So, just to
Without our
clarify,
knowledge, Joe.
But I think that in general, I think that by and large, the commission supports very small businesses that are operating, the little mom and pop operations of people that are operating very small businesses. They're not the large businesses that are out there that have been operating for a long time and just were not properly doing their business operation. That if they come in, we're offering the amnesty, come in, and they're probably going to get their special use permit, and they've not been creating any kind of a nuisance to begin with, and that they're, anything that they may have been doing that wasn't proper will be taken care of, and everybody is happy along the way again, because a lot of times it's kind of like it's not about the fence. I mean, to begin
Well, one of
with.
these
So,
lawsuits is.
but I'm just saying, sometimes but just in general, so that we continue, but I think that what we're looking at, though, and the fact remains that ultimately we need a determination, are we spinning our wheels by even issuing special use permits?
Right, and then do special use permits, do they always require that the person live at a residence or operate a business?
No, we have a handful out in the county that no one lives there.
Well,
Not very many, but
I
in
like
the future?
like to see these. I like to see these like home-based businesses. For businesses starting up. If you're willing to put a business in a residential area, you need to live there too.
can I ask a question? I just want to make another run at this with the county councilor. Your opinion is that SUPs, on the whole, in the state of Kansas and in Leavenworth County, are legal, and we have a legal basis for them. Is that your answer? Okay.
Commissioners,
Dave, did you have something else to add to that?
Commissioners, if I could, the old aphorism, how do you eat an elephant? One bite at a time. This is a bite. This is not a substantive major policy change. This really deals with the administrative handling of existing special use permits or the processing of future special use permits for businesses that have been inadvertently, and I would say, operating without a special use permit and should have had a special use permit to come in and get that permit so that county staff and the county appraiser and other offices are aware of their situation and provide them some protection too. This does not deal with the issue of up or down on the issue of special use permits per se. It doesn't deal substantively with your ability to issue conditions for special use permits. It deals with the renewal process, the annual review process, and the application fee for businesses that are, or entities that are found to be operating without a special use permit when they should have had one. That's it. It's not, I would call it a big picture fix. It's not even a big picture issue, but if you do not adopt this, you will start seeing again on your agenda renewals of special use permits that go through the process, and all they do is go through the process, a great deal of their time, their money, your time, staff time, and planning commission time for more or less what are preordained conclusions.
So if your opinion is that we are operating legally, then we can proceed with this. But I think Commissioner Smith is correct. The legal landscape is a little perilous as far as knowing what the judge will do. But for right now, the law is that we're
Commissioner, I think there are benefits to be gained with respect to the adoption of the proposed changes on an almost immediate basis. The bigger picture issues that Commissioner Smith is raising, which are very valid, are probably going to have to be dealt with on a much more protracted time frame.
Mr. Chairman, I do have just one more question.
Sure,
and I will be done. Crystal, so by going out there and saying we're going to give you 6 months, is that offer an amnesty? Is that a guarantee that this business is going to get to operate?
No, it's never been a guarantee.
Okay.
And that was direction from that we received from the board.
Right. So as long as they come in and apply, they'll have to come through the process, and if it's not a good fit,
Right, yeah.
they will not get approved.
Right. We're just saying.
Then they'll sue us. And
I don't know about that.
So,
The amnesty is simply for the $400 penalty.
okay.
That would be the only amnesty.
Yes.
All right.
Is that Mike?
Yeah, I had a couple constituent questions. The resolution speaks of substantial complaints. Who determines what is substantial?
It's actually a substantiated complaint.
Okay, they said substantial.
Our office largely determines whether or not it is substantiated. We get lots of phone calls from neighbors who do not like their neighbor, and we go out and we investigate, and oftentimes there is no real there's nothing actually occurring that goes against the special use permit.
It's not about the fence.
So we do go out, we do
Not
investigate
about the fence.
complaints when we receive them. And we're not perfect, don't get me wrong. I mean, if they say that they're operating
I thought you were perfect.
at 9 p.m., we don't have staff available at 9 p.m. However, we go out and we try to make more than one pass, to make sure that it's not a one-off sort of thing. We contact the business owner and say, hey, we're receiving this complaint. What do you have, what do you have to say about that? Like, can you, either this is occurring or not? And you'd be shocked at how often business owners are very honest, or maybe you wouldn't be shocked, but they're honest and say, yeah, we do need to work on Saturdays and such. And at that point, we've had a couple who've come back through early and asked for modifications to their special use permit. But just want to be clear that just because we receive a complaint does not automatically mean that we're going to bring something back through and say they're not abiding by the terms of their special use permit.
And do we have provision for a procedure for rescinding a special use permit in our
Yes.
rules and regs? And
Yes.
could you kind of walk us through what that is?
It's the exact same procedure for approving one. What we would do is we would bring it to the board and we would say, this is what we have received. These are the complaints we've received. We have determined that these complaints are valid, and then we would ask the board to direct us whether or not.
David?
And commissioners, in special events, I would call them, you do have powers both under the your county sanitary code in violations, or perceived violations that affect public health, safety, and welfare, to take more immediate actions. But the formal process for revoking a special use permit, not for perhaps taking immediate action to remedy a situation, you go through the same process as the issuance of a special use permit.
And then there is a provision in our regulations if nothing happens within a amount of time that the special use permit lapses.
There is a 1-year period where no activity is conducted, the special use permit is deemed to have lapsed.
Thank That's all.
Jeff, you have anything on this issue?
Well, just two things I want to bring up is, so this motion is about not making the applicant pay the fees over again, come back in, go through the process.
Right.
If it's basically a rubber stamp deal, it's saving time and money and costs. So that's a good thing. It's just streamlining the system we already have. And the other thing is, it's not changing the fact that an SUP can be revoked. Even though we're making them permanent, it doesn't mean they can't still be revoked for cause. If there's an issue that comes up, they can still be revoked. So it's not changing that. But I agree with what Doug's saying, except putting a moratorium on SUPs to figure out what we're doing. But I think the only legitimate ones really are the ones tied to agritourism. So I do tend to agree that we maybe need a work session on putting a moratorium on agritourism or agri-based SUPs. I don't think other SUPs need to have a moratorium on them for like a mechanic shop or something. Because I think the ones that you're specifically talking about that we probably do need to address are agri-based ones.
The agritourism, they may not need a permit.
Right, and
They
that's
may
what
not
I'm
need
saying.
one at all, so.
Yeah, I'm agreeing with you. I'm saying maybe we need to talk about those, but I don't want to put a moratorium on all
I
SUPs.
think we should.
If somebody wants to come in and get a SUP for a T-shirt shop in their basement, I don't think we need to not let them do that because of what you're talking about, is all I'm saying.
Right.
Thank you. You have anything else? Okay. Anything else for everybody else? All righty then. For this one right here, though, what we're talking about is I need a motion to approve Resolution 2022-8, amendments to Article 22, special use permits and temporary special use permits.
So moved.
Second.
Motion is second. Any more discussion?
No, I think we discussed it enough.
I think it's a good discussion, though.
No, I'm just got concerns, and I understand we're trying to streamline this. And I just want discussion and maybe some future meetings on
Yeah,
it.
I think it's a good discussion. Commissioner Smith?
Aye.
Commissioner Stephen?
Aye.
Commissioner Culberson?
Aye.
Commissioner Collins?
Aye.
And I vote aye. Very good. Okay. Consider a motion to approve Resolution 2022-9, reviewing and amending a portion of the comprehensive plan.
All right, Commissioners, this is the annual review of the Leavenworth County Comprehensive Plan. As you all know, my staff had numerous work sessions with you. We've also had numerous work sessions with the Planning Commission. At one of those work sessions specifically, we actually invited the public to come out. We invited them to speak, which, as you know, is not a typical work session. Typically, the public is allowed to come, certainly. However, we don't typically invite comment, but we wanted to have a very open dialogue and open forum before we presented a finalized amendment to the comprehensive plan. We had 10 or 11 people come to that meeting. We have, at your request, we're discouraging the rezoning and splitting of lots in already subdivided and developed neighborhoods. As Mr. Herring stated, there is difficulty determining exactly what a neighborhood is. From staff's perspective, the best marker we have to go from is the state requires us to notify within 1,000 feet of a property boundary for rezoning. So from our perspective, that would be a neighborhood. If you are within the notification area, that does certainly raise some concern, and I can see what that concern is. From a staff perspective, subdivided neighborhoods, that's very easy to understand, right? Subdivision, it either is or it is not. So staff would welcome some clarity on, do we just look at subdivided neighborhoods, or are we also looking at the neighborhood as a whole? So staff is certainly looking for that direction from you. The Planning Commission has recommended amending the future land use map. They would like to recommend that we go back to the original map that was proposed, that the Planning Commission originally recommended approval of. That map is in your packet. As you all know, the vast change to this map is that everything south of Evans Road is currently proposed to be 2.5 acre zoning. So you can see there the lighter green in the proposed original map is what they're asking to go back to. And then we also proceed with the proposed language amendments as outlined in the 2022 Comprehensive Plan Strategy Status. And I do want to go through this really quickly with you. On the back of these first two sheets, you have a chart. And one of the most important parts of reviewing the comprehensive plan on an annual basis is to see what we have been able to accomplish in the last year, what we're moving towards, and kind of like marking off. If you remember in the comprehensive plan, you have that long list. And commissioners, we've done a lot of things. If you take a look here, Public Works has done a lot of things. Our office has accomplished many things. Some of that is the special use permit language, adopting building codes. I mean, I think we've done a really good job. We had a previous comprehensive plan that I think if you went through it, nothing was checked off. So I want to be clear that is really the purpose of reviewing the comprehensive plan, is setting goals for the department, for the county. It's not just planning and zoning that should be involved in that. It's the Public Works Department, it's the commission, it's the Planning Commission. And we're getting some stuff done. We really, really are. So as far as the amendment to the plan, that amendment is really pretty small from the direction that you all gave me. It's essentially an asterisk at the bottom of whichever future land use map that we use that states, rezonings in established subdivisions / neighborhoods will not be supported by staff, regardless of where they're located within the future land use map.
You got yours big enough.
Big pictures, yeah.
I will open this up for discussion.
Is this what we talked about in the work session, though? I mean, is this what we came up with in our work session with Planning Commission?
The map, no. The asterisk, yes.
I have one question. On all these, on your comprehensive plan review, the ones that do not show being acted upon, are those like something you're still looking at? Or
Yes, of course. I mean, this is a 20-year plan, so there was never any intention that every single thing would be acted on in a single year. Yes.
Okay, because I know like this implement the Kansas City Regional Bike Plan, regional bike trails. When I went down to Baser, they're about the 155th Street project
and the parallel project.
Yeah, they have a really nice trail system that they've incorporated into it, and it's
about
really
have to get the money.
It's really nice. It'll be a great thing for the community, and I think that's when maybe we can get more funding when we're incorporating those things in.
You pretty much, that's a box you got to check when you're applying for funds,
And that's.
So in any future projects, yeah.
And
as far as going out and just doing it,
no,
not going to happen.
I'm not saying that, but
not in the same conversation we are talking about local property taxes.
But anyway, I think that's a great thing that's happening with 155th Street, and I think we can incorporate that as we move forward.
It's also the parallel project too.
Yeah,
155th,
which is quite a project. If anybody went down there to that deal,
if they wouldn't have changed the colors,
exactly,
then there's hardly any change at all. Do you know why they changed the colors on things? Like County Road 1, for instance, is purple on one map and crosshatch pink on the other, but it's the same exact thing.
Well, the County Road 1, we're just trying. So yes, at one point that was purple. We're just trying to very clearly define that's County Road 1. That has its own plan and its own zoning districts. Those are not being shown on this map. However, when you scale this map down, if you try to put all of that in there, the map becomes very difficult to. So this is blocked out. So we're not showing that on here.
It's pink on here.
That's the big one. That's the big one that they printed off that we have for here.
I guess what I'm saying is if they'd have left the colors the same from one map to the other, it would show there's very, very little change. It looks like a lot of change because the colors are different. Like the 5-acre area is dark green on the first map, but light green on the second map. So it looks like
for comparison. When we're comparing the
make sure you're looking at the right maps.
We got the right map.
There's significant.
Oh, these are the two we got.
Are you looking at this map here?
No.
You have two of the same map with just different colors, darker colors.
Those are different.
No, these are different.
One is the existing, and the other one is
The one that has
the
all of
future.
the yellow.
Okay, there you go.
But see how the 5 acres dark green on one map and light green on the other? That makes it confusing
It's
because
the
it looks
south
like a
end,
change.
most of the changes.
Right, the most changes
But really
at the
it's-
south end. Yeah. I was just-
The changes that were requested by the Board of County Commissioners when we adopted the comprehensive plan was to effectively take from Evans Road, everything south was to be 2.5. And you can see on what was presented to the board,
This is what we have.
you know, we
currently
still
adopted.
had some 5
This is
acre
the
zoning
recommendation.
down through here. That was a substantial change.
And did we get an explanation from the Planning Commission as to why? I mean, part of when we're changing the comprehensive plan,
So what
a lot of the
that is,
changes,
all
as
of
we
this is
visited about, have been very incremental.
2.5.
This change
But then-
appears to be
Yeah.
a wholesale change of the map,
And then all of that
where maybe there are some areas like
Not.
west
This
of
is
Rocking
2.5.
Sea, I could see a 5-acre argument,
It's now
but to
meaning
completely
5.
come in here and completely
Yeah.
If it were the same color, it'd be
reinstitute
Yeah.
a different map, I think that's problematic because what's going to happen is we have developers and we have landowners and we have business people that are working under the expectation of the current land use map, and then we've only had that in effect for, a little over a year, and then we come in here and propose that we completely rechange the land use in the southern part of the county, which actually has the effect potentially of devaluing people's land. So
exactly what it is.
I think it's problematic to
They can come in
redo
and
the
ask
entire
for
map.
rezoning.
I'd like to return this to planning and zoning and tell them, show us a few areas and give us a justification for the map changes, and make the map changes be incremental, not wholesale. That
Your area down there had the highest appraisal increases, didn't they? Linwood area?
yeah. So
You need more houses
this,
down there.
this is a problematic. I think one of the reasons we changed that consultant map was because they put all these islands of 5 acres within there that were adjacent to 2.5, and the justification for the neighbors. Well, here's the neighbor. He has to live under the 2.5, so he's going to get a negative recommendation from planning and zoning. But right across the way, even on the same section, you're going to get a 2.5 recommendation. So we said we don't want to have all these islands. Now, out west of Rocking Sea, if you look at that map, I don't have that other map.
258th Evans?
Yeah, I mean, if we do along the entire western border, we could go 5 acres all the way across, and I could see an argument for that, but I don't see that the Planning Commission made an argument for that. They just upset the entire apple cart and bring us an entire new map. And so if you have a good justification why they didn't do this in an incremental fashion, I'd be interested to hear it.
That's what I was talking about
Yeah.
at the work session.
Yeah.
I didn't remember this.
This was not part of our work session.
Well, there was some discussion.
Right. Yeah, there wasn't. The asterisk, like, that we just approved that, or not approved, but we just discussed.
We
was-
talked about,
But redoing the map was not part of our work session.
there was some discussion. I mean, it may not have been on the agenda.
Yeah. But if we could send this back and have them come and say, well, here we have a justification from the Planning Commission. Here's our reason and our argument for making this change. And it would be an incremental change. It wouldn't be the entire map. I could see that working, or we could wait till the next review. But I would suggest that we changed the map for a reason.
Well, the problem I have is it's hard to vote for the new map for me because it's changing it to the way I made my district anyway, with 5 acre tracts on gravel roads, 2.5 acre tracts on paved roads. This is changing the south end to that. So it's hard for me to vote against the new map when it's making it like my district. But what I'm concerned with is the vote was 7. There were 7 votes out of 10 on the commission. The majority of those 6 that voted for it, I don't think were even on the board when we went through the comp plan. When we were doing the surveys and listening to the folks and listening to what they wanted and the map that we created, wasn't something that we came up with. We were just listening to the majority of the folks, and that's the map we came up with. And so that's what concerns me, is the majority of the people who voted for the new map weren't here listening to all the people like we were. So,
And we made
that's a problem for
changes
me.
to the comprehensive plan, significant changes when it came to some of their ideas about conservation of land and some of their ideas that didn't really match the policy positions of the commission as far as what our direction was. And then the other thing is, people have to be able to plan if they're a builder and they're trying to build these subdivisions. They can't have the county commission one year saying this is the land use plan, and the next year come and redo the entire plan.
And I'm sure you've got that in your area. People bought property based on the comp plan.
Well, I know this one area by 32 Highway, I think there's some really major homes that are some subdivisions being considered there. And I'm not against change. There's parts of this map that, especially west of Rocking Sea, I can see a good argument. I would suggest we return it to planning and zoning and have them give us a incremental approach on the map, tell us a good argument.
Kristen, any comments on that?
We can certainly return it to the Planning Commission. That is absolutely. I will say, from a staff perspective, a year and a half is not really very long. That's, I hesitate to set the expectation that we're going to change the future land use map every year. I think that's confusing to residents.
No, and I agree with that. I think we need to look at it every year.
And I think we all maybe get a little hung up on this map and feel like this is the most important part of the comprehensive plan, and it's just a part of the comprehensive plan. And as Commissioner Culbertson pointed out, when this map was originally brought forward, it was brought forward at the direction largely of the Board of County Commissioners, because we did want to see 2.5 acres along all paved roads, and then we wanted to see 5 acres along gravel roadways, because gravel roadways, obviously we want less traffic than on paved roads. And that was the consensus at the time. And then when it came through, we did make some changes to it, and those changes did not go back to the Planning Commission. The Planning Commission did originally vote on this map, and they did support the idea of 2.5 on paved roads and 5 acres on gravel roads. So I think that's their justification. You are correct; there are new members on the board, and that will always be that'll always be the case. However, I think just the Planning Commission, they felt like we didn't give this original map a chance. And whether or not that's true, I don't know that really matters too much. However, I do caution against setting the expectation that we're going to change this map every year, because again, I think that's unfair.
It's to be reviewed.
I think the purpose of the annual review is to address things that have come up over the last year that don't fit, or if a use has changed in a certain area. It's not to make a large scale change. It's to identify an area that maybe development's changed, like down on the 32 highway where some of these subdivisions are coming in. Maybe the usage has changed there, and you want to reevaluate what's going on in that area at the time, but not to just make the change because it's a year's up and we're going to go ahead and change the whole south end of the county. And it does need to be consistency, and the annual review is more to just identify issues and address those issues.
And to your point, I think the intent is to be incremental. We tweak. Maybe this map, maybe there is some changes here that need to be made incrementally, but to come in and just redo the entire south end of the county on the land use, that doesn't seem appropriate.
Well, I guess I would say back when we approved first one, I was the
Stay
one
with
I
it?
voted against.
Oh.
I voted against changing the original. I voted for the original map that the Planning Commission was wanting to support originally, and was not in favor of the changed map that we ended up adopting. So I'm
But
kind of in, and I told you so.
People are making their plans based on the
What?
Welcome to my boat.
So it's kind of like, I mean, I can see that what happened, I kind of say, hey, can the people that have purchased property, anticipating the current map, get grandfathered, and then we look at the potential for maybe changing.
And I think that's because of what we heard. The reason we went with that is because your district and my district, we were hearing more people saying, why do we have to buy 5 acres when we only really want 2.5? And people in the South were saying, hey, our taxes are getting really high. We need more houses to lower our taxes. So we addressed that, trying to predict.
But there are some areas, like as I specifically identified west of Rocking Sea, that I could see along the county line that we could change. It could merit changing. So I wouldn't mind returning this to the Planning Commission and have them look at it again.
I agree with Crystal, though. You just can't switch gears every year.
Yep, that's the problem.
We got to. I support reviewing this every year. And like I said, if there's a major development, or if there's something major like Hill's Pet Food and Tonganoxie, and something changes there, and annexation, stuff like that.
Well, and I like the idea that Mr. Herring brought up. Let's do a hard zone. Come up with a map and do a hard zone. Then you're not flipping back and forth. But the logistics of that, I mean, to rezone the entire county, sending out notification letters to every single resident is what you'd end up needing.
Take a long time.
Doing.
How'd we go from 10 acres to 5 acres? I sure don't remember any big rezoning.
When you start making these kind of changes, and I think I've heard a couple of times, people are concerned that what's the county going to do next year when they review it, or in a year and a half, are they going to go back to 5? Are they going to put some things in like that? I think this one hasn't had the opportunity to be successful yet. It seems like it's working well.
I think it's successful.
That's what I meant. It hasn't had. If it's going to be a failure, we haven't seen that yet.
Right.
And as it may be a better way of putting it, to go back and relook at it, I'm happy with the way it is. We've been operating on it, and maybe we need to take a look at a year just to go back and forth to have a work session, just to say that I think what we're all thinking. Mike, I'm not sure we need that. Maybe there is a 1 or 2, but maybe we bring it up next year. But I don't like tampering with this thing every year.
I agree, but I do think folks like to have an opportunity to be heard. And
No, I agree.
what I have a problem with, though, is the wholesale. We're doing the whole thing. I mean, I don't think that was necessary. I think if you have specific locations, then give us a reason why and bring that to us. And that should have been done in terms of this map, and maybe a good argument made. But to me, it's like we didn't like that the map was changed, and we're just going to put this other map up for you to consider. And that's really not enough reason to change the whole plan.
Okay, Commissioners, where do you want to go?
I just soon stay with the map
I
we got.
am too.
So if we don't do anything, that would be
Yeah,
what we did.
that's what I.
Now, I just want to make sure I'm clear. This doesn't change my district at all.
No, there were no changes to it.
Okay, I just want to make sure I was reading that right. Yeah, that's what I want to make sure. Wasn't fine print somewhere. Okay.
No, there are no changes, no changes.
Just for the people down in my area, I'm going to make a motion that we return it to planning and zoning to look at the area west of Rocking Sea. And put that as a motion.
Have a motion, any second? Okay, it dies for like a second.
Okay.
So, on your motion, was we going to stick with the original plan and then revisit it again in October when our year is? If they can work on this and then revisit it again in October, we just stay on the existing plan until our next review?
Right.
Was that part of your motion?
Yeah.
Then I'll second
Okay.
it.
We need to redo the motion.
Okay.
your motion.
I resubmit my motion as stated.
I would like a little better clarification.
Okay, I
Say
resubmit.
that again.
No, your motion is to,
My
So
motion.
maintain the current map.
Maintain the current map, send it back to be reviewed, and that review will take place and be submitted at the next yearly review,
And that'd be the end of October.
end of October. And hopefully we can expedite.
Crystal?
Yes, so speaking of that, that's actually something that I would like to talk about. So state statute says that we need to review the comprehensive plan on a yearly basis, and it needs to be done by June. I do think there's a little bit of confusion because, Commissioner, October is not very far away. If we begin our yearly review process after we've just reviewed it and we start that in October, we've barely given any time at all. Really, that yearly review process would begin roughly now. And then we shoot to have it adopted by June. So you want to you really want to give, 9, 10, 11 months of.
I think what they're trying to say, Crystal, is instead of making sure
Whenever
we don't end up
just
18
make it.
months, we get it done in the year timeline that we've talked about. Even if we start now.
Right, so I just want to
But
be
we don't
clear.
want to wait 18 months.
If we stick with the original map, Commissioner Stevens' motion, then we have completed our review by June, and we just start over again next year. Is that correct? Is that part of your?
That sounds
That's
correct
what
to
I
me.
want. That's what I would say.
Then I'll
Same
second,
thing you're saying,
Then I'll
Crystal.
second your motion.
Motion second. Any more discussion on this one part of it? I'll call the roll. Commissioner Smith?
Oh, I did have discussion.
Go ahead.
There's been some discussion about preserving agriculture. The landowners can do that. If you own the land, you can register and preserve your land as agriculture. It doesn't, shouldn't be the county commissioners telling you what to do with your land. And I honestly believe we have enough ag preserve with all the floodplain we have, with Missouri River floodplain, Kansas River floodplain, Stranger Creek floodplain. We've got a lot of places that are never going to be developed. So, anyway, that's all I had.
And along those same lines is when they're doing rezoning decisions, they have the issue of the character of the neighborhood that they can always take into account.
Okay, I have a little bit, I'm confused now.
This is just one issue we're voting on now. So
Map.
We're voting on
the map.
the map to,
Leave it the way it is.
So it's going
Well,
back
that's
to planning
reviewed.
and zoning to be reviewed, but it'll be reviewed on the timetable that Crystal outlined.
so we're voting to reject the Planning Commission's recommended map? Is that?
We're sending the map back to be reviewed further by the Planning Commission.
But it won't be until next year.
I don't want to use the word reject.
Okay, sorry.
But the one thing that would be, because one thing that Mike said, it would be nice, since you got it here again, to put in there the reason that maybe they said for certain areas. But the motion now on the floor is to keep it the way it is.
Okay, yeah, I think that's what we need.
Yes, that's what they're doing.
Okay, so clear.
It's got turned around, but the motion is to keep it.
Is to not
another
accept the
year.
recommendation, because we're not accepting the recommendation of the Planning Commission, is what I'm,
And we're returning it to the Planning Commission for further comments and review on the timetable that you outlined,
that's why I'm
Which
confused.
is a year
Okay.
off.
which
The annual review.
normal review process.
in the review process,
Yeah.
but we want it to be looked at, and we need specific reasons and incremental.
So we want to make sure that next year in February-ish, when we begin reviewing this, that
Right.
if they want to make changes to the map, that they give us clear reasons why in specific areas, not wholesale.
Right.
However, today, we want to we want to adopt the rezoning caveat that we've all talked about and keep the map as it
No,
currently-
we're just talking about the map right now.
doing
Then
the
we're
map
getting-
right now.
That's
We're
the-
just the map.
Okay.
Because that's why I'm confused. So resolution, so
We'd have
what,
to vote to reject the resolution or deny the
right, that's
resolution.
why I said, what we have before us is a resolution reviewing and amending a portion of the comprehensive plan.
So my
So-
motion is to return the map to the Planning Commission for further review on their timetable. The result of that is that there's no change in the map. We don't have
Which
to
means
vote.
that we're not approving Resolution
We're
22-9.
We're not approving their map.
But we're going to have to make a motion to deny
David,
it.
David.
That's a
We have
motion to
make a
deny.
motion
David. Can,
You don't have to.
Commissioners,
Okay.
you are by state statute required to annually review your comprehensive plan. The statute does not say annually change your comprehensive plan. You have been presented this morning with a proposed resolution that would affect a change of the comprehensive plan. If upon the conclusion of your review, you find that no action should be taken, you take no action. And you simply state, we have completed the annual review. We shall look forward to the next annual review to be initiated by planning staff.
So by my motion, it's just returning it and saying, we want you to look at this, but we're not going to take it till the next time.
David.
But their
we need that.
recommendation is to change
That's what
the
they
map.
do anyway.
We're not worrying about their recommendation.
I'm confused.
Hold on.
I think you
You're saying the
achieved
same
your purpose
thing.
by
We will be
simply
changing
saying
the map.
we've completed our annual review, no action to be taken.
So you're going to.
But that doesn't address, what I was trying to get addressed was to allow it to go back and let the folks know that we will review
Well,
out
we
by
need to-
occupancy
we can
that
make
area.
a
We can make no motion, we can give direction. We need to get this first part done.
Okay.
I'm
Then I
just,
withdraw my motion.
I'll withdraw my second then.
Okay.
I'm still not clear what happens if we approve Resolution 22-9.
We'd be changing the map, right?
We will be changing the map to the recommended map that
That the planning commission
the
submitted.
Planning Commission has brought to us through their review.
If you were to make a motion to just approve the recommendation of the Planning Commission.
Resolution.
Of the
Right.
resolution, yes.
Okay.
If you were to make a motion to not adopt this portion of it, we would modify the resolution to clarify that.
So that's so we need a modification
It's
of the
only one portion.
resolution.
You'd have to bring that back to us.
Yes.
So,
That's what I'm trying to get.
Gotcha.
So we have the map and we have that little language amendment.
But it's all part of one resolution.
Right, it's
Right.
currently
And you're
part
not
of.
approving that resolution from the sounds of it. Maybe you're all going to change your mind here, but it sounds like you're not going to approve that resolution. And therefore, the current map will stay in place for another year.
until the review, and you've heard what the issues are for the review.
Yep, that's down the road. What we're doing right now is saying we're not going to approve this, period.
So then you
Don't
can
do
read the
anything.
you can read the resolution, but the vote then would be nay.
We don't have to.
We don't have to act on it.
Take
Oh,
a name.
okay.
We don't take the vote.
Okay, deny. All right. There we go. There we go.
Okay, clear as mud.
All right. Then I move that, Mr. Chairman, I move that we have completed our annual review of the comprehensive plan, and there'll be no changes.
Okay, now does that affect the plat issues and all those things
You need to address that separately.
separately?
Commissioners, I would suggest you don't need to take or have a motion at all. Simply reach a consensus that upon the completion of your review, that you've determined that no action will be taken, and simply make that as a declaration, not necessarily a motion.
Then I'll withdraw my motion.
That's doing the same thing. Okay.
Okay. So we've done it now.
Yes.
Yes.
It's
And
done.
we've
All right.
completed our
Crystal.
annual review.
Now, if there's interest in the change, the modification of the little, basically the rezoning issue, if there's still interest in that coming forward, you can direct us to that. We will redo the resolution to only address that issue.
I think we are interested in that, aren't we?
How we rezone the whole county? according
No,
to-
the subdivision.
Oh.
Crystal, why don't you just step into that one right now?
I like how you put that.
We need
Could you
a,
rephrase that?
if the board
Step on
could give
that.
direction, if they want us to bring just that portion of those changes back, we can do that. But I need that to be a consent, or actually, if you,
Okay. And we were talking about that earlier, was basically a platted subdivision that has an interior street. Is that what we were talking
I think we need to be
about?
careful, though, not say platted subdivision.
Was it a developed platted subdivision?
Well, there's a lot of.
Don't say
there's
platted
some interior
subdivision.
streets, though, that never
It
were
can be
platted.
small tracts in an area that are all
Well,
5 acres.
Mr. Herring was talking about there's some that had to be platted as subdivisions and there's no houses there.
Right, but what we want to address is if a neighborhood, which is a broad term, has already established they're all 5 acre tracts. They don't have to be lots in a subdivision. They could be 5 acre tracts.
Yeah, why don't you get that together and make that language just perfect and bring it back to us?
Doing my best, Commissioner. So,
As I stated earlier, yes. So the neighborhood versus subdivision. And Commissioner Culbertson, you were absolutely correct. Before, I think it was 1996, I think, 2006, sorry. You could develop tracts of land, you could develop tracts of land via survey. It did not have to be platted. Since 2006, it's had to be platted. So there are examples where we have, 5-acre tracts stacked one on top of another. They're not platted. But they were clearly developed as 5-acre tracts. How far out do we look? Like I said, from a staff perspective, 1,000 feet.
The definition of the boundary is going to be difficult.
But 1,000 feet.
That seems fair.
Yeah, that's way too small.
Oh. Well, that's true, because you could have
Quarter mile.
a quarter mile. Yeah, a quarter mile I think would be probably better.
But so then, let's look at a quarter mile. And let's just pretend like this isn't an intersection. And we have 5-acre tracts that are developed all at the northeast corner of that intersection. But then directly across the street, you have a 160-acre tract of land that hasn't been touched.
It's going to be real hard to come up with a definition.
Which one is it? Because staff truly doesn't know. We really don't know which one we're supposed to look at and give greater weight to.
Well, first and foremost, this is just a recommendation. What we're saying is, regardless of how that language plays out, it's just a recommendation from staff for either approval or denial. All the other conditions still have to be weighed, and it still has to go through the process. So even if we made a change that everybody could agree on the language, and staff made that recommendation, let's say to denial, they still go through the process, and the board can still grant that based upon
each case
some change, because there are so many variations.
Yeah.
It's impossible to address all of the issues. I think the character of the neighborhood is really what you're talking about here. We're just trying to make it so that the character of the neighborhood will get a recommendation of denial if you could somehow define what the character of a neighborhood is, other than personal opinion. So this language is problematic from an enforcement standpoint. Joe Herring's language in his email and in what's included in here, it's very accurate. I think it changes too on, was there a transfer of ownership? Did some of the lots transfer or did they not? Or maybe if one person owns it all, that changes everybody's attitude on whether it can be rezoned. So it may be in this case that as we handle it now may be the best way going forward, and that this board ultimately gets to make the decision on whether or not that's approved or denied. If you don't believe it meets the character of the neighborhood, you're not going to allow it. Now, does that mean people may apply and get their hopes dashed when it comes to the board? Absolutely. But I think that's really the only way you can address every possible scenario.
Yeah. They're all going to be
You've got 5 acres on one side of the road, and you got 160 acres on the other side, and then it decides to be developed. I think it should be able to be developed in the current comp plan.
Well, it's kind of like
this is to stop 5-acre lots from being further
Resplit, replatted, right. But
Right.
when you're talking
And
about a
established
character of a
5-acre
neighborhood, though,
neighborhood.
when you got a large tract cross that's never been touched,
Well, I think
deals
that-
off.
Right, that's
I think one of
different.
the issues that
You can buy it.
Mr. Herring brought up was this
You can buy it.
situation where maybe you have a platted subdivision, but there were 40 acres in there that were required to be platted. The other lots, let's say they're all 5 acres. What would stop the person who owns that 40 acres from coming back in and making those 5-acre tracts? I think that the
All the
board
same
would
number.
probably support that, but if they wanted to come back in and make them 2.5-acre tracts, maybe not. And that's why the process we have in place right now addresses that. Without this language, it's just procedural. And I think we were trying to get to a point where people didn't think they could just automatically do this. And that's still the case going the way we currently do it.
So you're saying just leave things?
I think that it's impossible for us to address every
Very
possible
clearly,
scenario, and
Yeah, makes sense.
that the hearing process is the way to go.
Okay.
Good with that. Everybody else?
Once again, we'll let the courts decide that.
Okay. Anything else, Kristen?
I don't believe so, Commissioners. Thank you.
Thank you, Kristen.
Thank you.
Yeah, thanks a lot.
They just bring trouble. You're welcome. So I'm here for anytime.
Oh, okay. Moving on to presentation discussions. I don't think they're in. Mark, do you have anything else? That's enough. Commissioners report. Doug, I'll start with you.
Okay, Basher City Council meeting last Wednesday at Paramount Township last Thursday. Attended a fundraiser at Basher BFW for Chris Derringer. Had suffered real bad COVID. Hinted at, and tonight I'll attend Anna Mary's visitation and probably attend the funeral for that tomorrow.
Mike?
Just working with the city of Linwood on their submission for ARPA.
Mike, you might want to mention, too, that we were successful since the county commissioners all voted to have that letter done about the gas line down.
Oh, yeah, but, and I haven't brought that up yet because I haven't seen the final deal, the final ruling, but there was a decision made to maintain our Atmos infrastructure within Leavenworth County. And
to add lines.
And they credited the county commission's letter for being a very critical part of that. So,
that's an important utility down there.
Yeah.
The way that's growing and the school down there and everything.
it just shows sometimes we don't think there's, because we're kind of the lower rung on government, but when you write a letter like that, it can impact.
Well, and we've sent letters of support for fiber optic internet, high-speed internet through that county, and there's a lot of cable getting on, but it's not getting to everybody, though.
Yeah.
Of course, the ones that aren't getting it are concerned and want to know how they can get it, and you just got to contact the internet provider and voice your concerns.
I think
See what it takes, if it's so many houses in a mile or what, I don't know.
I just think that's a success for the little guy, if you want to say it like that, because a lot of times people think that just because they're a handful of people, they come up and they ask for something, that they're just wasting their time. And this is exactly when we try to work together and get things accomplished. So,
And people may not know what the story was. There was a application for a withdrawal of service and pulling of lines from Atmos Energy down near the gun club down in the southern part of the county and affecting a couple other landowners. And they actually hired their own attorneys, but they also approached the county commission to object to that. And we said, this is one of the fastest growing areas of the county, and that it doesn't make sense to be pulling infrastructure out. And that was submitted, and I'll give our county councilor credit for drafting that and submitting that, and was successful.
Especially with the new school being down there.
Yeah.
Yes.
When the school, they'll build around it.
and that was some of the reasons we brought up. You're absolutely right.
Right.
Anything else, Mike?
Other than the Linwood issues, no.
Okay. Jeff?
I just want to make a plug for the June 14th at Haymarket. We're going to do a benefit for Council on Aging, Meals on Wheels. All the proceeds will go to them. We'll have 2 or 3 bands playing, food trucks, bounce house for the kids, stuff like that. So,
And they're looking for sponsors.
and we're going to be looking for sponsors. So anybody interested can contact
We're
me.
going to have to park here at the courthouse and walk down.
I hope.
We'll get a float.
Okay.
Anything else, Jeff?
Is it?
Vicki?
Let's see, I did the Kansas City Area Transit Authority meeting Wednesday afternoon, which was a very long meeting, and I facilitated via Mark to do a letter of support from KCTA for the state of Kansas. So thank you, Mark, for getting that put together, and that we sent it to KCATA yesterday afternoon, so hopefully that will be forwarded to the state for KDOT. And I think and there was no city commission meeting last night, so that's it.
Thank you, Vicki. I just have just again on the gas line, I was very pleased to see how that turned out. And again, Mark's already brought it up, just a reminder, Tuesday at 6 at River Community Center, joint meeting with the City of Leavenworth, which we have done, and I can't remember when, so I hope it'll be, and I'm sure it will be productive. With that being said, I'll take a motion to adjourn.
So moved.
Second. Mr. Smith?
Aye.
Mr. Stevens?
Aye.
Culberson?
Aye.
Collins?
Aye.
Aye. We are adjourned. Thanks, everybody.